All right, as folks make their way back from break here, we are going to, we've got some great content for you here to wrap things up with the session. So certainly we're anxious to start presenting that and get on to the second half of our program here. So without further ado, Richard Turner is going to discuss fiduciary considerations for public schools with you. So take it away, Richard.
Thanks, Brian. Sorry, you won't have Mike and I going back and forth on this. You're stuck with just me for a few minutes, but I think we'll be okay. One of the things that I want to mention at the outset of talking about this topic is that as plan sponsors, your role is to look out for your employees. So there's never a question, at least hopefully there's not a question about whether you're looking out for your employees. What we're going to talk about is something much more specific, and that is the extent to which you may have sort of a heightened level of legal responsibility with respect to what you're doing under your plans. And we're going to talk about, so that's the topic, fiduciary considerations for public schools, and their focus is going to be on 403B. But for those of you, if you decide that the discussion today or this morning is not enough and you wanted to drill down even further, many of you know Jackie Fabatore-Matheny in the back. She's got the copies of an article from BNA that I had the good fortune to write along with Bob Architect on this subject that drills down into a little more detail. So thanks for waving, Jackie. So if you want any more of information on that, feel free to ask Jackie for a copy. Here we go. I want to start out with, because I always like to start out with sort of with myth busting. And we've got four sort of popular myths that go across the full spectrum here about the status of school district plan sponsors as fiduciaries of their 403B plans. Okay, one is that public schools are never fiduciaries with respect to their 403B plan. Well, that's not true. The flip side is that they're always fiduciaries. That's not true either. The next one is that you always want to be fiduciary, so even if you're not, you should want to be. Well, that's not true either. And then you should never, the last one is that you should never want to be. That one's not true either. So you're probably sitting there thinking, well, okay, well, if none of that's true, what's true? Well, the way I think it's important to look at this topic is that all of those statements, all of those myths, really put the cart before the horse. Okay, because your role in maintaining your 403B plans is to provide this benefit to your employees. Your focus is on what is the benefit that my employees want and or need. How do I go about providing that? How do I want to go about providing that? And given the state of budgets, at potentially at the lowest cost and or the lowest potential future risk to me as the plan sponsor, how do I go about doing that? And then, once you've decided on how you want to structure that plan, and it's really up to you, it's not for the benefit of any of us up here, it's for you and your employees. Then you look at, in the way that I've structured this, am I a fiduciary? Okay, so that's the way I would encourage you to look at that. Fiduciary status, again, a lot of people will sort of use that term very generically as if, basically saying, I'm looking out for my employees. Well, yeah, of course, your role as employer is looking out for your employees, like I said, whenever you're providing benefits. But the term fiduciary really is a specific legal standard. And that legal standard has essentially two components that you see up there on the slide. One is a heightened level of responsibility. So you take on greater responsibility with respect to how you implement your plan for your employees. And the flip side of that greater responsibility is the potential for liability if you don't get it right. Now, Marilyn's going to talk a lot about, she's going to talk after I do, after I finish this, she's going to talk about ERISA rules. Because there's a sort of a long history within NAGDA of sort of recognizing that there's some good to be gleaned out of ERISA provisions, even for public sector employers that aren't subject to Title I of ERISA. All right, so that's one of the things that Marilyn's going to talk about. But she's also going to talk about in her slides, not to steal her thunder, but she's also going to talk about some of the litigation that is out there with potential liabilities then for those plan sponsors. So it's just, I would just underscore that those two things go together in determining, number one, am I subject to these to this higher level of standard? Not just, am I doing something that I think is a good thing, but have I taken on a particular role for which I could have some additional liability? That's not to say it's a good idea, a bad idea. First, figure out what you want to do for your plan. So with that, if it is a legal concept, which it is, then where does it come from? I want to start with talking about where it doesn't come from. The first, we heard, many of us, I think folks in this room will know this very well. After the final 403B regulations came out, you had a lot of sort of confusion out there, miscommunication, people saying, first of all, that all 403B plans, including public school 403B plans, are subject to ERISA. That's not true. That you're all fiduciaries just automatically. That's not true, because there's nothing in the regulations that deals with fiduciary responsibilities. And Ed Salyers will be out at, as Mike said, will be out at his booth, and you can talk to him throughout the conference, and he can talk to you a little bit more about that. But the regulations do not impose fiduciary responsibilities. They impose compliance responsibilities. So does ERISA impose fiduciary responsibilities? It absolutely does, on plan sponsors who are subject to Title I of ERISA and public employers are not. So far, so good, right? What about state statutes? Well, it's possible that some state statutes may impose fiduciary responsibilities on you with respect to your 403B plan. We'll talk about that a little bit more. And the last one is, well, what if you're not subject to it and you decide you just want to do it? Can you do that? You can, but we're going to talk about that some more. So what do the states say about fiduciary responsibility? You'll hear folks sort of talk about this in various presentations, and they'll make reference to state uniform laws. There are various state model laws that can impact this discussion. One thing I would mention to you is that for the most part, those model laws do not create fiduciary responsibilities, but they tell someone who is a fiduciary how to execute. So they don't answer the question of whether you're a fiduciary from a legal perspective under your 403B plan. Well, what about the state pension statutes? Those generally do impose fiduciary responsibilities, but if you look at those, what you'll find is that they generally impose fiduciary responsibilities with respect to the investment of the assets of the state pension plans. So they generally, I'll say generally because somebody may identify a particular state where this is not the rule, but generally those do not apply. Those statutes don't apply those standards to locally maintained 403B plans for school districts. Well, what about state and local 403B or 457B governing statutes? And this is one where you can get that, and I'm sort of branching into 457 here for a moment just by way of example. In California, the statute provides that state or local employers maintaining 457B plans have a fiduciary duty with respect to the selection of the investments available under the plan. That same provision does not apply for 403B plans. In fact, in California, as we've already heard earlier today, it's an any willing provider law state where not only does the employer not take responsibility for it, but they're subject to very significant restrictions on the ability to limit. But let's contrast that with 457B plans, because I don't want folks to miss this. If you have a trustee 457B plan, even if your statutes don't impose fiduciary responsibilities, a trustee by definition is going to be a fiduciary, all right? And so those other statutes that we talked about might have some impact in determining what the standards are for the trustee. But that's the trustee, so if that's a third-party trustee, that's the individual who then sits in that role as a fiduciary in that respect. Yeah.
Could you have an employer have three different plans against all three tax codes where they're fiduciary in one and not?
Okay, I want you all to know that I did not plant that question. That's a great question. I wanted to say that first because that is a great question. The question was, if you're a plan sponsor, if you have multiple plans, could you have a situation where you're a fiduciary for one and you're not for one or more of the others? The answer is absolutely yes. And that really underscores that it's a determination that you really have to make on a state by state, or excuse me, state by state, on a plan by plan basis. But here's the good news that I forgot to mention when I was, we were going through the list that IRS and the code and ERISA don't apply these fiduciary standards to public school districts. There's a piece of good news in that. And that is that the question of whether you are fiduciaries has nothing to do with the code or ERISA. It has everything to do with state law. That's the wheelhouse. That's right in your district's council wheelhouse. Okay, it's a question of state law. It's not, and that's something that your council is just regularly advising you on. Where are we? What are our responsibilities? What should we be concerned about? What kind of procedures do we need to have in place? So this is a question that they are very well able to answer.
Richard?
Yeah.
Provide just a quick example of how you can be a fiduciary for one but not another.
Okay, the question is, how can you be a fiduciary for one but not for the other? It goes back to the sort of the original point, which is there's nothing inherent about the plans that makes an individual a fiduciary. So you could have, in California, for example, if you are the plan sponsor in California and you maintain both a 457B and a 403B plan, then you have a statute that says you have fiduciary duties with respect to selecting investments for the 457 plan. You don't have a corresponding provision in the California statutes that tells you that. Now, let me be clear. I'm not providing legal advice to anyone in this room. And I'm not licensed in California, so let's hope that's on tape. So, but I'm just giving those as examples, and so that's why the council, it's important to look at within the context of each plan. Oops.
Yeah, so it's correct to say that there are no fiduciary statutes for 403B in the country and in California?
No.
Okay, the question is it correct to say that there are no fiduciary statutes that govern 403B anywhere in the country? The answer is no. That's not correct. Okay, again, I can't advise you. Right, well, oh, I know how that works. The question that you have to ask yourself, and actually more importantly, you have to ask your counsel, is there a statute or is there a court case that imposes, or a statute, a regulation, or a court case that imposes fiduciary responsibilities on me? And the answer, is going to be different by type of plan and in many cases and by state. But if I'm in California, you've got the any willing provider statute. It's hard to say that I, as plan sponsor, am responsible for selecting the investment products when I have to allow any product that is on the 403B Compare website in my plan.
And the only other thing I would say, you have to look at your plan document, because a lot of 403B plans have used ERISA plan documents that impose, fiduciary without acknowledging that you're a governmental plan. So it's possible to write fiduciary rules into your plan document.
That's a good point, because that's one of the things that was on the earlier slide, too.
Right.
And I was going to say to that, Steve, there's, I might be the only person in California who thinks this, but when the 403B became subject to a plan document through the new regs, I think that it technically brought it under California Government Code Section 53609, which is essentially what gives 457 fiduciary responsibility. Again, I may be the only person who thinks that, but at the same time, that rule, or that if in fact I'm correct, it is in direct conflict with Insurance Code Section 770.3. So either way, there's this strange nebulous of fiduciary responsibility in California, but I think if one wants to attempt to put it under there, they could. It's just that no other attorney in California or the United States agrees with me at this point in time. But I'm willing to work on them.
Well, yes.
Short of the fiduciary specifically being named either by title or something else within the plan document or the specific government statute, who then is
We'll get into that in the next,
Well, but-
and it
but-
really is based on the functions the person's performing, so.
Well, but you raise an important question because, and Marilyn, you're right, Marilyn's going to get into that talking about ERISA, but remember, ERISA doesn't apply to school districts, okay? It doesn't apply to public employers. So your question actually starts with a premise that there is a fiduciary somewhere. We've got to figure out where they're hiding, okay? The answer is there may not be one. You know, fiduciary as a status is a legal construct, and it either exists or it doesn't. I'll give you another example. You know, I've been talking about all of this, but you know, here's one example where every school district probably has fiduciary responsibilities under their 403B plan. You're going to say, well, that contradicts what you've said. No, not really. With respect to the remittance of contributions, you are essentially holding those contributions for the benefit of those employees. And so you have a duty, whether it's technically a fiduciary duty, perhaps under some common law, or otherwise, you have a duty to remit those contributions or have them remitted on. And so, you know, there's, from a legal perspective, there's a general concept of constructive trustee, that you're holding somebody's funds, so you're responsible for them. Again, this is not giving legal advice by any stretch of the imagination, but in the absence of something like that, there may not be somebody who is technically a fiduciary, and that may not be the more important question. The more important question may be, what is it you want to do for your employees in structuring your plan? Okay, so let me, Marilyn did make a very good point that the plan document itself, you know, please, this is a word of encouragement. Whenever you are adopting a written plan, and I'm not trying to make work for your attorneys or create sort of full employment for attorneys, but whenever you're looking at adopting a plan document, please make sure that your counsel is involved in that process. Because to Marilyn's point, you've got to make sure that that plan accurately represents what it is you want it to do. And I say that because assuming that we get the final prototype guidance from the IRS for 403B plan documents, down the road at least, you know, probably a couple years at least, there will be plan documents that you will be able to adopt as prototypes for 403B. They don't exist today, but there will be. When you do, please make sure that you and your counsel have looked closely at those documents to make sure that they reflect what it is you're looking for, so that somebody, as Marilyn pointed out, somebody doesn't just hand you an ERISA document and you just adopt it, you know, not realizing it. And you take on responsibilities that maybe you didn't have to or didn't want to. Okay. Again, I really want to emphasize the primary issue. Don't put the cart before the horse, and don't let others sort of push you into putting the cart before the horse. Primary focus for you is, what do you want to do for your employees? What are the right answers? Whether that's one provider, multiple providers, somewhere in between, whether it's coordinated compliance through a vendor or a TPA or yourself, however you structure that, first and primary question is, what's the right thing for you and your employees? And then when you do that, as we sort of already talked about, you determine whether whether fiduciary rules apply, and if they do, figure out what is the source of those, so you know what standards you have to satisfy. So, for example, if you decide that you are a fiduciary with respect to your plan, your 403B plan, then you might, you know, pull out the slides that Marilyn has that she's going to talk about here in a few minutes and say, this is the way that I want to follow, these are the standards that I want to follow, since I believe, and my counsel, more importantly, believes that I'm a fiduciary. And I meant to just share a couple of examples with you, because I would encourage you to, with your counsel, you know, in just answering the basic question, working with your counsel. I want to give you, I promised, I think, on one of these slides, and I think I passed it, but to give you a couple of examples of state statutes. And this is, and I'm just going to sort of pull these out because these are in the article that Jackie has back there. Arizona statute specifically says, the employing body or county school superintendent shall assume no responsibility other than to make the requested payments during the actual time of the employment of the employee. Now, obviously, that hasn't been updated for the fact of the 403B regulations, but it certainly doesn't bring in a fiduciary standard into that language. Florida has similar statutory language. Let me just the purchase of such tax-sheltered annuity or other investment qualified under the United States Internal Revenue Code and not prohibited under the laws of this state for an employee shall impose no liability or responsibility whatsoever on the employing agency except to show the payments have been remitted for the purposes for which deducted. Back when these 403B permissive statutes were adopted, in a number of states, not all, but in a number of states, there was language in there that protected the employer. I think, and I'm going from memory now, but I think it's in Ohio that there's actually a requirement that the participant, that the employee sign an acknowledgement that the employer is not responsible for the selection of their investments. Okay, so on a state-by-state basis, it does vary. And by the way, if that article is too short for you, we got a longer one too, but I figure that'd probably be enough. So then once you figure out, do I have fiduciary responsibilities? Okay, and again, this isn't about, don't get caught up in, well, if I don't have fiduciary responsibilities, that must mean I don't care about my employees. That's not it. This is a risk management question that you have if you're not the risk manager, with your risk manager, with your counsel. If you determine that you are not a fiduciary, that's great. If you determine that you are a fiduciary, are there ways that what are some of the things I can do to limit my potential risk? And again, Marilyn will talk about ERISA as sort of possibly a go-by, as an example of standards that you might follow if you decide that you already are a fiduciary or you're going to undertake responsibilities that make you a fiduciary. Then that will give you something to go by. And when you're looking at ERISA, again, sort of, you'll see, just using ERISA as an example, that there are pluses and there are minuses in any of these standards, including, if you find that you're a fiduciary, make sure that you've really tacked down your procedures, because if it's determined then later by a claim from a participant or however it comes up that you didn't satisfy your obligation, the level of obligation or responsibility, then that's an opportunity, subject to claims of sovereign immunity and other protections that may be available. There's a possibility that they're for liability for the school district. So it's not just a nice thing to do. It's if the standard applies to you, make sure that you're taking the appropriate steps. And then I think Marilyn's going to talk about fee disclosure too from an ERISA perspective. I know many public employers are looking at fee disclosure as again, as has been common within NAGDA and governmental plan sponsors, sort of looking at some of the best that you can pick from ERISA that may be helpful to your plans. One of the benefits when she's talking about fee disclosures, you're going to hear some things that are good, and you're going to hear some things that, I don't know that I want to do those. This is liberating. Okay, you have the flexibility to pick the things that you want and not necessarily take them all on. And I'll just leave it at that, and I'm going to turn it over to Marilyn to talk about it from the ERISA perspective.
Okay, great. Yeah, we thought we'd go over these basic fiduciary responsibilities, because even if you don't feel like you're a fiduciary, or you're not a fiduciary under your law, you've talked to your counsel with regard to your 403B plan. Many of you have 401A plans or 401K plans or 457B plans, and you are fiduciaries with respect to those plans. And even if you're not a fiduciary for the 403B plan, all of these concepts are very good things to keep in the back of your mind. Just because you're not a fiduciary doesn't mean you should go out and breach your responsibilities by conflicts of interest or some of those things. They're just very good concepts to operate your plan by, even if you're not taking on the fiduciary mantle. So we'll go over some of the ERISA rules, how they apply, who is and who isn't a fiduciary. And I think you'll see, once you see what the responsibilities are, complying with them is just common sense. And then we'll talk about some of the fee-related lawsuits, as Richard mentioned. So we already know that governmental plans are not subject to ERISA, but there are statutes in a number of states that are modeled after ERISA. The Uniform Prudent Investor Act contains language that's very similar to ERISA, and many states have adopted those statutes. And when you look at the state statutes, they may vary from ERISA, but they never conflict with ERISA. I mean, fiduciary concepts are pretty widespread, whether you're looking at a state statute or at ERISA. Now, ERISA is much more detailed, which is why it's nice to look at it as a guide. I think one thing to keep in mind is when you have your employer hat on and when you have your fiduciary hat on, because it's very different and you need to know when you're not liable as a fiduciary. So the decision to have a 403B plan or a 457 plan is an employer decision. It's an employee benefit. You've got your employer hat on. How are we going to design it? Are we going to allow loans? Are we going to allow hardships? Are we going to allow that 15-year catch-up? Or now that the rates, the contribution limits are so much higher, and we have the age 50, are we going to eliminate that because it's burdensome? Amending the plan document for permissive decisions is an employer decision. You didn't have loans, you want to add loans, that's a permissive feature, that's an employer action. Now, updating the plan for required IRS regulations and things like that is a fiduciary action. And then we talked a little bit about terminating a plan. Well, you'll see in a minute that if you're a fiduciary, you always have to act solely in the best interest of the participants. When it is in the best interest of the participant to terminate the plan? Probably not. That's the employer decision. They're again deciding what employee benefits to offer and which ones not to offer. So those are things that you do as an employer, not as a fiduciary. And the difference can be key, because if you're a fiduciary and you're doing something to benefit the employer, that's when you can really get into hot water. So general fiduciary concepts. This is just, when are you a fiduciary and when are you not? Well, generally it's when you're acting on behalf of someone else, not on behalf of yourself. So if you have a trust deed plan, a 457B plan, and you have to act solely in the best interest of the participants, then you have fiduciary capacity. Who's a fiduciary? Well, we talked about whether you're named in the plan document, and if there's nobody named, then who is the fiduciary? Well, if it's a 457B plan and there's no one named in the document, you look at what functions the person is performing. If you're a 403B plan and you've decided or determined that you don't have fiduciary responsibility, then maybe there's no fiduciary, but that doesn't mean there isn't someone that's operating the plan and making sure that the plan is operating for the benefit of the participants and not for the benefit of the employer. So fiduciaries are, anyone who has discretionary authority over the plan, the operation of the plan, the assets. If you're otherwise subject to fiduciary responsibility, anyone who's exercising control over the administration or assets of the plan is a fiduciary. So that means, like in the 457B context, choosing your trustee, choosing your service provider, selecting the funds. And sometimes I have plan sponsors say to me, well, I'm not a fiduciary because I chose a record keeper and I chose my trustee. So they're the fiduciaries. I'm not a fiduciary. And you have to make sure that they understand that just the act of choosing those people was a fiduciary act when you have fiduciary responsibility, like with your 457B plan. So even though a plan sponsor who's otherwise subject to fiduciary responsibility can get other fiduciaries out there on the hook with them, they can't alleviate their own fiduciary responsibility. So with regard to your 457 plan, you're always a fiduciary. And with that co-fiduciary responsibility, let's say that you convince someone to be a fiduciary along with you, maybe an investment consultant or advisor or whomever. You have to be careful if you make them sign up as a fiduciary to monitor their actions more closely. Because if you find out they breach their duties and you don't do anything about it, then they can cause you to have a fiduciary breach, which is never helpful. So who's not a fiduciary? Well, those people that are just doing ministerial functions, or maybe they're advising you, but they're not making decisions. So attorneys, accountants, consultants, actuaries, they're typically not a fiduciary. They're doing services, but you're making the decision. The fiduciary is making the final decision. Service providers such as record keepers are typically not fiduciaries. So it's important to know who is and who isn't, and it's based on their function and what level of discretion they have. So, okay, we know that in the 457B context, at least, we are a fiduciary. So what does that mean? Well, there's really 5 things that you have to think about. And sometimes I've done these speeches and I'll say, okay, how many of you decided to go out and breach your fiduciary responsibility today? Let me see a show of hands. No hands, that's a good thing. Now, who can name one of your fiduciary responsibilities? No hands there either, right? But once you know what they are, as I said before, I think it's really common sense. So acting solely in the best interest of plan participants, carrying out your duties prudently. And when we get to the lawsuits, that word prudent is in all caps, underlined, bold, 5 exclamation points, right? It's not what the action, it's not the result. It's how you got to that result that is dependent on how the cases come out. Following the plan documents. This has got to be the most boring thing anybody ever thought of doing, is reading the plan document. But it's very important. You can't operate in compliance with it if you don't know what it says, right? So it's very important to know what your document says. Diversifying plan investments, and almost everybody does that well. And paying only reasonable plan expenses, which if you decide to use the new fee disclosure rules that ERISA plans have to use, will make that determination a little easier, because you'll be getting the information that you need to know what you are paying, which is also one of the problems that has arisen in the lawsuits. Okay, the exclusive benefit rule. I'm just going to use one example of this, loyalty and the avoidance of conflicts of interest. I did an RFP for a big 401k plan in Denver a couple of years ago, and they said, boy, we would love to have Great West be our record keeper. And as soon as Great West starts buying all of its paper products from us, you'll get the contract. So they had their employer hat on, not their fiduciary hat. And that's really the loyalty and avoidance of conflicts of interest. Prudence. Now, this is the duty to act prudently is one of your central responsibilities, and it's at the core of all these fee-related lawsuits. It's a process. And if you need help, you can hire people to help you. It's an obligation to be competent and careful. It's, the care, prudence, skill of a person who's knowledgeable and working with a plan would use. Know your plan document. We've talked about that. It's really the contract between the plan sponsor and the plan participants. You have a duty under the code, whether you're a fiduciary or not, to operate in compliance with the plan document. So you need to make sure that the procedures and the policies that you've written match the provisions in the plan document. And we've, in audit, have seen the IRS fine an employer for allowing, in the 457 context, allowing people to do that final 3-year catch-up without first setting out what their normal retirement age was. And the plan document says you can't put a contribution in catch-up unless you first tell the plan administrator your normal retirement age. Well, everybody was eligible, but they hadn't done that step. So they weren't in violation of the code, but they still got fined for not operating in compliance with their plan document. Prudent investment procedures. This, as we talked about, is very difficult in the 403B context where they have the any willing provider law. It's impossible for an employer to monitor and select and deselect when they have so many investors. But this is important on the 457B side to make sure that you're monitoring your investments, your service providers. An investment policy statement can be very helpful in this regard. It sets out how you go about selecting, monitoring, evaluating, deselecting investments.
Marilyn, do you mind if I throw
Sure, no,
quick
please.
thought in there on the investment policy statement? One thing, if you adopt an investment policy statement, make sure you follow it,
Yeah,
because
exactly.
it becomes a roadmap for determining whether you did what you were supposed to do.
Yeah, that's very true. It's better not to have one than to have one and not follow it. And looking at the cases, and I won't have time to go into them in any detail. If anyone wants to ask me about them later, I'd be happy to talk about them. Huge fines were imposed against 401k employers, like $35.2 million in one case, for not following their investment policy statement. So it's very important. Retaining a service provider. The employer can't do all of the things that are needed to do to have a plan work properly. You need record keepers, you need trustees. So there's no problem. The law even encourages you to retain people to help you if you need it. If you think you need an investment consultant or attorneys, whatever it is, you can hire those people. You have to do it prudently. It's a fiduciary function if you're otherwise a fiduciary, and you can delegate, but it doesn't get you off the hook. The plan fiduciary is still liable. And with regard to monitoring, I think it's good to have a formal process, but at the least, if you need to monitor a service provider, you're reviewing their performance, you read whatever reports they give you, you review the fee disclosure documents that many of you will be getting now that the new DOL rules are in, ask them questions, and if there's participant complaints, then certainly follow up on those. Everybody that has service providers would have an agreement, hopefully, with the service provider. Just monitor that and make sure that whatever they agreed to do, they're actually doing. It's not a real difficult thing to monitor based on what the parties have agreed to. So breaches of fiduciary duty, well, they're the flip side, right? It's self-dealing. It's requiring your service provider to order your paper products. It's not exercising prudence, right? It's a failure to diversify or monitor and engaging in a conflict of interest. So steps for managing fiduciary responsibility. One thing that Richard just mentioned a little bit, or someone did, about getting your contributions in on time, making sure that you've got the money and the allocations going in on a timely basis. Now, ERISA has kind of as soon as practicable as rule, and then but no later than rule. And you want to make sure that you're getting them in as soon as you can, because the IRS rule of thumb on this is how long do you have to get your withholding to the IRS? If you're taking withholding, federal withholding, out of someone's paycheck, how soon do you need to get that to the IRS? If you can get it to the IRS, let's say 3 days, you ought to be able to get the contributions in 3 days. That's kind of a rule of thumb. And I thought it was interesting with respect to 403B. I was giving a talk in Chicago about this rule. And this lady raised her hand and she said, well, now we take the money out of the participant paychecks and we put it in our bank account for 90 days. And the whole room just went, ah!
It's okay because that's Chicago.
Yeah. So then as as each one gets 90 days old, we take that money and we send it to the 403B provider. Are you saying there's a problem with that? That would be a yes. You know, and many times I'll get questions like that, but usually not in front of the group. They come afterwards and whisper in my ear. But I think that she was new. They told her, this is how it works. And she heard me say something different, and she just wanted to make sure she was doing it right, you know? So I felt sorry for her because everybody was just, I can't
Maybe she
believe
was
it."
from out of state. I don't know.
Yeah. So you need to just, you know, review your document, make sure your fiduciaries, if you have fiduciaries, make sure they know who they are and what they're responsible for. Some people have a committee for investments and a committee for administration. Some have one committee that does everything. So just make sure they know what their responsibilities are, and maintain records. That's the other thing we're going to find out in the lawsuits, is that you need to document that you have a process and that you followed the process. And those employers that can show that win the cases every time. It's the ones who either didn't follow the process or can't show that they followed the process that usually end up in trouble. So now we're going to talk a little bit about the fee disclosure regs. They only apply to ERISA plans, and some vendors may be doing things differently, but Great West has determined that we are going to provide the service provider fee disclosure, the ones that go to the plan sponsors, to all of our employers. So all of our employers are going to get the covered service provider fee disclosure. Governments, churches, ERISA, everybody. And it doesn't apply, of course, to the governmental plans, but for ERISA plans, if the fiduciary doesn't get this information, that agreement is deemed to be an unreasonable agreement under ERISA. So they have a brand new fiduciary duty here to get the information. And if they don't receive it, the service provider won't send it to them, they have to terminate the contract. So this is a new mandatory fiduciary duty to receive and review the information. Doesn't apply to governments, but many of you, I think, will be happy to get that information. It'll help you see what you're paying and who you're paying it to. That's the first piece of the fee disclosure regulation, service provider to plan sponsor. Then the next level is, does the plan sponsor want to provide fee disclosure information to their participants? ERISA plans are required to. If you're an ERISA plan and you don't provide it, you may be in breach of your fiduciary duty. Not so with governments. And there's two pieces to the participant fee disclosure. And this is important because we have an SEC issue with regard to the initial and annual disclosure that doesn't apply to the participant statement. So there are really two pieces, initial and annually thereafter, and then a second set about what you have to provide quarterly on your participant statements. So a new mandatory fiduciary duty under ERISA. And the outstanding SEC issue is with regard to the initial and annual disclosure. Because what that requires, it requires a bunch of plan-related information, which most people are already providing. How do you, what are the investment options? Who are the investment managers? How do I go about making my investment decisions? I mean, things that they have to do just to sign up and operate under the plan, right? They're getting that in some form already. They're getting a lot of the investment-related information also. We do investment options at a glance, fund performance sheets. There's a lot of stuff that participants get. But to comply with this new DOL rule, all the investment-related information has to be in this side-by-side comparative chart. And that side-by-side comparative chart that's required by the DOL does not match the SEC requirements in Rule 482. So you can't comply with the DOL without violating the SEC or vice versa. So the DOL went to the SEC and asked for a no action letter, which they got. The SEC said, if you are, first, required to comply with the DOL rules, and you do comply with the DOL rules, then we will not take any action against you for not, crossing all the Ts and dotting all the Is on Rule 482. And the differences are really some of the timing issues. And for example, the SEC requires that you do yield when you do income on money funds. There's just a few legends and other things that don't match up. So as far as ERISA plans are concerned, they can comply with the DOL rules, no problem. But the issue there is that it says it's only if you're required to comply. Do you get this relief? And governmental plans are not required to comply. So Spark and a number of other, like 15 industry organizations have talked to the SEC, and they've said, please give non-ERISA plans the same relief. The SEC seems willing to do that, but they haven't acted yet. Another letter from that industry group answering some SEC questions is going in again in about a week, so we hope to get relief. One other issue, Richard mentioned you may be able to pick and choose which rules you want to use and which ones you don't want to use, and it appears that the SEC is going to say that in order to get relief from the SEC rule, you must comply with the DOL rule. It's one or the other. So you might not get to pick and choose as much as we would hope, but we don't know yet because they haven't issued the letter. It doesn't apply to the quarterly statements. So many vendors are already updating the quarterly statements for those governmental plans who choose to provide this fee disclosure. Many governmental plans have already been providing a lot of fee disclosure. Their participants are used to it. They think it has all the same information, just maybe not in the same format, and they're happy to keep using what they already have. And if you think you've got robust fee disclosure, you may not want to change. So I'm going to just talk about the fee-related lawsuits very briefly, and there have been a number of them. And the fee disclosure may heighten the interest in these cases, but plan sponsors now have to get the information, they have to review the information, and these cases were all decided prior to this. Like regard with revenue sharing, the participant said the plan sponsor didn't disclose that there was revenue sharing, and the court said, well, there's no rule the plan sponsors disclose revenue sharing. There's no rule that they disclose fees this way, that way. And now that we have the new rule, that may change the outcome of some of the cases. But that one recent case that I mentioned seems to have rolled up all the various allegations into one. Some had like 2 allegations, 3 allegations. The allegations in this one case was that they failed to follow the plan's documents, they failed to monitor record-keeping costs, they failed to select and retain funds prudently, and they allowed the plan to pay excessive fees. And in this case, they were told by their auditors that the fees on the 401k plans were way too high, and the reason that the fees were too high was because they were subsidizing the employer's payroll and some other plans. So the 401k plan was funding a bunch of stuff that benefited the employer, right? So bad facts have shown they didn't act prudently, they didn't follow the documents, they changed their funds in violation of their investment policy statement, And they chose and their investment policy statement said if there are several classes, you must choose the least expensive one. They chose the most expensive one so that they could get more revenue sharing because the employer had agreed to pay whatever the revenue sharing didn't cover. So there again, they were acting on their own best interest. It wasn't going to come from the plan participants. It was going to come from the employer. So the court found that they had bad motives, no prudent process, and they were fined significantly.
Marilyn,
Yeah.
I hate to go back, but it took me a while for it to sink in what you said. And because this is being recorded, what should plan sponsors take away from what you said about the conflict between the SEC and the DOL?
What we're doing at Great West is telling all of our plan sponsors that if they want to provide the initial and annual disclosure using the DOL comparative chart, that we're happy to do that as soon as we get SEC relief.
So no action really, they shouldn't.
Well, if they want to do something without us, you know. The other thing would be is to make sure to do a different DOL chart, side-by-side chart, and add all the stuff that the SEC would require. And I don't know if vendors are going to do two sets of those or not.
Yeah, if I could just add, one of the big issues that Marilyn's talking about here is the fact that the annual disclosure requires data as of the end of the prior year. And the SEC and FINRA require updated to the end of the most recent calendar quarter. So essentially what you have in the required disclosures for ERISA plans is, from the securities perspective, considered stale data. And so unless... And as Marilyn said, there are a lot of conversations going on, and it may be that the SEC and FINRA do agree to recognize it even for non-ERISA plans. But until then, you can't really provide that information.
So there's been a number of cases, some for the plan sponsor, some for the participants, and it's not really the choice that the plan fiduciary made, but whether that choice was prudent and in the best interest of the plan participants. And with that, I'm going to turn it over to Steve.
Thank you, ma'am. All right, is everyone ready to run out there and create your own 403B now? After are you sufficiently scared to death? Or all right. Well, I'm going to tell you why you should do it. So hopefully we can help you out with that. Again, I'm Steve Toole from the state of North Carolina. I've got a great crew here with me. I'm also pleased that my attorney's here with me, so he can keep me honest when I go astray. Responsible for 13 retirement systems in total, and should I move that? There we go. And we got a defined benefit plan, one of the best funded plans in the entire country. We're about 95% funded on our state plan, and our other large plan is the local plan. We're right at 100% funded. We have about $78 billion in assets of our defined benefit plan. We like to say it because there's not many that can say that. And we have about 875,000 members across the state. It's an interesting fact. It's a big state. It's 1 in 8 North Carolinians we touch, and we take a lot of pride in that, and we also take a lot of responsibility. But despite being well-funded, we still get a lot of noise from our General Assembly around is our defined benefit plan sustainable for long term? And we're gearing up for a potential fight next year around potentially a hybrid plan or some type of DC option. I think that exists every year. It's just a world we live in, right, Julia? On the defined contribution side, we've got a 401k, and 975 of our employers participate in that. $5.7 billion is the largest 401k in the public sector across the country. We serve 227,000 participants. 457, we've got 248 employers, 38,000 participants, and $862 million. The state recently launched a new feature, which we really like. It's a transfer benefit, so participants can take their 457 or 401k assets, transfer it back into the defined benefit system, and then receive a monthly annuity off of that. So they can, for a $100 one-time fee, they can move that back into the defined benefit plan, and then we will price them out a lifetime income for the rest of their life and potentially their survivor. That's a unique feature that we are very fond of. And of course, we've got the 403B. Our partner with third-party administration is Prudential, and we are currently out to bid for a 403B. So there's probably not a whole lot I can say, but I'll walk you through kind of where we got to. And I was hoping to tell you who our new vendor was. We've launched, but we had to reissue the proposal, and I'll tell you more about that. So what are our goals of the retirement system? Very, very simple. The reason why I left the private sector and moved into the public sector was to help 875,000 people prepare for retirement. And right now, we know that 56% of our members age 62 or older have saved at least 80% of their income in retirement. And they've replaced that. So we're very pleased about that. We've got a ways to go, though. I'm looking for 100% to make sure that everyone is prepared for retirement. The whole issue around the whole fiduciary thing, we take very seriously. I grow concerned around as more and more baby boomers try to retire and don't have retirement income they need. I think there's a day coming where you're going to see employees who look at their employers and say, did you do everything you could have done to help me retire? And I think that you may get asked questions around that, and your processes and procedures may get questioned. To that end, we had Groom Law Firm come in and help us from our fiduciary perspective and help us around best practices, educate our board, educate our staff, and it was a tremendous 3 hours spent, and I would encourage you to think about that as you are running these plans and for these a large number of participants. So with that, I want to slide over and give you a 403B update. This all started back in 2010, actually before my arrival at North Carolina. The treasurer, whom I work for, initiated a future retirement study commission with the defined benefit plan, and a couple of things came out of that. They looked at hybrid plans for the DB replacement. They looked at the 403B option. They looked at automatic enrollment, automatic increases, and things like that. The things they decided to move on after thorough research with our fiscal research team in General Assembly, we had a separate committee made up of educators across the state, financial experts, a number of board members that are in this industry. They decided to move on to 403B program, and they decided to move on automatic enrollment and increases. So then to help part of the reason why they decided to do that was they leveraged Department of Public Instruction, and they surveyed all of our 115 school systems, and we got 83 responses, and 85% said they would offer a state-sponsored program. So we are confident that once we get this thing up and running, that we will get adoption. And a number of them have actually said to us that they are looking to go exclusive in this situation with the state. So we're very pleased about that. Part of the things that in North Carolina, and I know this isn't true in every state, but part of the things that they looked at was that what they saw was an industry with a kind of an antiquated business model. It's an antiquated business model in that you see high fees. There was a lack of concern around compliance monitoring, and there was lack of oversight by the plan sponsors. They really didn't know what their obligations were and what their responsibilities were. And I work for a treasurer who takes pride in making sure that we do everything we can to help our employers and our employees to be successful and to guard against those complaints or concerns from the public. We then, House Bill 730 became law on July 1st, 2011, which created the, I'm not going to say all those words, but it's just the North Carolina 403B program. We probably could have used some marketing folks to help us name this thing, but that's okay. I just call it the North Carolina 403B. The law passed really simple. I mean, it was a simple process. And then it's like all of a sudden someone flicked a switch. And the switch was flipped, and then the entire industry of 403B vendors came to us and said, what are you guys doing? You're running me out of business. You are just. It was a extremely difficult conversations, but coming from the industry, I understand. I believe there's enough business out there for everybody. There's no doubt about that, and I believe it's an industry that needs to be shuffled up a little bit. Right now, what we see in North Carolina is there are fees. And this isn't true for every single vendor. I'm not naming names or anything like that, but what you'll see on some plans of fees upwards of 2% with extremely high-end performing or fund fees because they're getting more mutual fund reimbursement back. And on top of that, you're seeing fixed annuities, which I know is pretty standard in this business, but they're collecting 2 and 3% off of that. So we felt a need to try to drive costs down, increase awareness, and move more money into participant accounts rather than to the coffers of the vendors. And we want everyone to make a fair share, but we think that teachers deserve a better retirement. So that created a lot of angst, and it really created there was some really bad behavior, and there's some good behavior as well. What we saw was we saw some folks really passing out the kind of misconceptions, mistruths. There were some statements out there around that they're going to mandate the state plan be offered to every school district and it be exclusive. That's just not true. Every school district in the state will have an option to add the plan or not. It's their choice. It's just going to be another option. We feel confident they'll add it because we believe we'll build a good plan. So we went out to bid for a consultant and hired our friend here, SST Benefits Consulting. And Scott and Barbara and Bill have been doing a fantastic job for us and helping us through that. The RFP was released on May 25th, 2012. Responses were received on July 11th, and then we had to reissue the proposal because it was a little, I think we probably could have worded it a little bit better just on our end because of our own procurement, that some of the requirements weren't met all the way to the degree that we felt confident. And given the kind of the angst and concern, we wanted to really make sure we do this well, so that at the end of the day, things are positive for all parties involved. And our responses are due now, I believe October 11th. Does that seem right? Yeah, all right, good deal. So what will our vendor do? Our vendor, we will hire someone that will provide a menu of investment alternatives. We will look to our partner with SST and the board of trustees to select our funds, and then we will the vendor will actually administer those investment options for us. I'm pressing Scott. I want the top decile of funds and performance, and I want top decile in fund fees. I want to be extremely aggressive. I'm confident we'll be able to get, because I know, I come from this industry and I know how these cases are priced. When you can offer 115 school districts to someone, they're going to be competitive and you got scale behind you and you can bring that to the table. And I'm confident we'll see lower fees. So you're seeing more and more states do this, and this is an industry trend, I think, across the entire country. And I'm really pleased North Carolina got on board, and I'm really pleased we got the industry and the vendors inside North Carolina on board and aligned around what we're trying to do. Those vendors that have built great relationships and continue to serve those employees, they'll absolutely be able to do that, and I think that's great. The end is helping people to save and retire the way they want to, and they can do that through multiple means. We offer the 403B program of record keeping, participant services, reporting, marketing, communication, and education. We will administer the plan according to the locals plan document. That was something that we got some good advice on. It'll be important for us to administer the plan to their plan document so that they don't have to administer another plan document, because we felt that would preclude people from actually adopting the plan. We will leverage the existing compliance third-party administrators that are in force. What we will do, though, is we will, and this is something we haven't figured out yet how to do, but we're going to figure it out, but we will evaluate that compliance third-party administrator to ensure that they are in full compliance with all laws, rules, and regulations, and that they're doing things the way they should be doing. And if they don't pass that, then we won't add the state plan. We won't expose the state to additional risk through a vendor that is not doing what we feel like they should be doing. The employers are behind that, and they're looking to the state to help them be successful. We will also create our own plan document, just in the event that we got some local employers that want to be exclusive with the state. So if they want to do that, we don't know how many will do that, but if they want to, we'll be prepared. And so the main goals behind this was just really lowering of fees and full compliance, and in the end, helping our teachers to retire ready in the way they want to. So our vendor will market the program to our local school boards of education, and we're hoping that all 115 school districts adopt. I doubt it, but we've got a number that have already compressed and went down to a much smaller number. You're starting to see that across the state, but we're a very large state, and there's a significant rural part of North Carolina that just don't have the horsepower in order to do that. So hopefully the state can step in and help from that perspective. The local boards of education will have sole discretion to add the program. As I said, they can offer it exclusively. They can add us side by side, or just not add the program at all, which is fine. They'll have, again, the full the authority to continue with the compliance third-party administrator. We'll review them to make sure they're in compliance. And we have a supplemental retirement plans board, consists of about 10 members. A couple are actually in attendance with here today. And they will provide the oversight of the all the relationships, including the staff. So we have the Supplemental Retirement Plans Board oversees our 457, our 401k, and they also are going to oversee the 403b. So we'll have all the existing processes that we have in place today to monitor funds performance. We'll hire an investment consultant ongoing once we get past the RFP process of the selection of the vendor, and just continue to do that on a best practice. We'll issue our investment policy statement and ensure that we are in full compliance with that. But at the end of the day, I think that, I'll share this with you. I was recently in New York City at the New School, and there was a rather large, the whole discussion was around retirement readiness across the United States. And it was actually, they invited a number of us from the state side to talk about retirement readiness for the private sector. And what they're saying, we talked about how the 403b has evolved, and they're looking for states to actually evolve, even some on the private sector. We learned there that 44% of North Carolinians in the private sector do not have access to any retirement system whatsoever. And those are just scary, very scary statistics. You're talking about 4 to 5 million people that are potentially be poverty stricken once they retire. And that was part of the reason what drove the 403b. We believe, and I'm very confident, that we will offer a very competitive program. I think it'll continue to evolve the market, and it'll help people to save for retirement. This concludes my remarks. I'm open to any questions, and I got 1 minute for questions, so thank you. Yes.
There's been attempts here in California to change the 403b, and it's going nowhere. There doesn't seem to be political will. Is there any good political will in what you get?
Yeah. Well, it goes kind of back to what I said. We got the law passed, and I think it got passed under the radar, and to be very honest with you. And once it got passed, that's when we heard a lot. And I ended up having town halls with all the broker dealers, and I think it was, I had to go across the street to our General Assembly and talk to the key people and help them understand that this wasn't about replacement. It's not. It's not about putting North Carolina broker dealers out of work. Regardless of what you're doing there, you got to give people more choice. And I think you have to educate on facts. There is no doubt it takes immense political will, and it takes a lot of patience, because you're going to face arguments that aren't fact-based. They're more emotion-based, and they will. Let me say North Carolina, I had to defend the truth and what we would do and what we wouldn't do. And once we got there, I think we were fine. And part of my challenge in North Carolina was that there's national associations that really, I believe, I think kind of, I would question the integrity of the information, whether they didn't get good data on what we were really doing in North Carolina, but all the broker-dealers got kind of misguided on facts and details around what we were doing versus what we weren't. And as a result, it really got them motivated and it really got a lot of energy stirred up. But once I sat in front of them, talked to them just the way I am now with you, and said, you've got questions, you come to me. I don't believe others. Here are the facts. And once I got them past that, and I had a lot of open meetings in my office with people, but it does take political will. But you've got to believe that what you're doing adds value, because it does. And we believe we'll offer a great program.
Great. Well, we certainly thank all of you. We couldn't have asked for better on a Sunday morning audience. You were terrific. And please join me. Our panelists were outstanding. Thank each of you for a great job today. With that, we're here all conference, and certainly we'll be around here if you do have any last questions or things pop up. We'd love to help, and thank you for spending the morning talking through this important topic. Have a great rest of your conference.